express language of the model penal code and constitutional principles. And so on that basis, we submit our motion to dismiss.
O'Leary, were you first?
And maybe let me address the remaining events as well.
So I'm a little concerned about getting through this. So what I'm gonna do is just deal with Ms. Brunel's motion so that at least I would be able to rule on one thing if we have any issues going forward.
I think my argument is going to be abbreviated much based on that. I'm not going to relitigate those argument, but yeah, I think all of it is a producer by applies to the events. Just level out.
Okay, so I will hear from you, but I just wanna deal with Ms. Brunel first.
Thank you, Your Honor. And I guess I want to go through points made by the other counsel here with regard to Ms. Brunel. And I want to do so in the context of sort of going over some of the things I put in my written response and then a few other things to note. But with respect to Ms. Brunel, one of the reasons I had sort of stood up and interrupted, is it Attorney Jennings? Which reflects in, yes. Jennings, all right, I mispronounced it. Attorney Jennings was, because the state believes that there is video from before what's being shown here that is instructive for the court in understanding Ms. Brunel and what happened with her and why she was arrested with regard to what I say in my response is instance number one, as opposed to instance number two, once they're let out and they're behind sort of a false wall, curtain sort of a thing, and then there's a response at that time. So, what I would indicate to the court is a couple of things, because I think it's important to understand this case in context, and I'm going to discuss my understanding and my reading of Murray, but I'm going to ask the court to take a look at that, because that's clearly a case that they're relying on. And I read Murray a little differently, and I read what the direction is from the Supreme Court on Murray a little differently than they do. But I would leave it up to the court. So first, I think what I would indicate to the court is that the situation, okay, the context that this sits within is a context of a couple of prior things happening before in time that sort of inform the state police and their response and how they were dealing with the situation. So first and foremost, there was a meeting here in Concord at the Brown Building, which is called the Old State Office Complex, having to do with Health and Human Services and implementing some rules changes to allow for funding to come in having to do with the vaccinations. A number of the people who are involved here today, and I can say specifically 4 of them because they had a signage in sheet, were there. And they made their presence known, and they made their presence known in a way where they disrupted a meeting on September 9th, so that that was not able to go forward. Ms. Brunel was present. Mr. Staples was present. And in addition, I believe Mr. Stewart and one other individual from the group of 9 that are here today were present at that. And it was clear that they were upset with these changes, and they were upset with what these changes in policy would mean with respect to this item and this issue. Then you come forward a couple of weeks to September 29th, 2021, and there is a meeting with governor and council that is scheduled to occur at St. Anselm College in Goffstown. And again, a number of the individuals who are here today are present and involved in it. And I can certainly indicate that I know, based upon some reports, that Mr. Staples was there. And they're not happy with the fact that on the agenda for governor and council there's going to be discussion about some of the issues that they don't agree with. And the notion of funding and the notion of...
You don't know what we were unhappy about.
Perhaps changing rules with respect to what they think is appropriate. They disrupt that meeting. They disrupt that meeting to the point that the governor and council discontinue and don't have that meeting. And they don't have that meeting, and I will say this is a matter of public record because it was on the news. There were statements made by people in the crowd about, we know who you are, for various members of the governor and council's executive council, and we know where you live. Based upon that meeting was discontinued. As the court well knows, governor and council meet to do things like nominate people and have those things approved. They also meet to discuss contracts and things that where there may be federal government money coming in. And they conduct business that is necessary and important business for the state. And they do so in the context of the governor and council meeting. But they also do so in the context of our state constitution, which I've cited, but I think it's important to our record to talk about it, because I think it's the nub of the issue here from the state perspective. Part 1, Article 8 of our state constitution indicates, with respect to government officials, it says accountability of magistrates and officers, semicolon, public right to know. All power residing originally in and being derived from the people. All the magistrates and officers of government are their substitutes and agents, and at all times accountable to them.
Damn right.
Government, therefore, should be open, accessible, accountable, and responsible. To that end, the public's right of access to government proceedings and records shall not be unreasonably restricted. So I think where one of the issues that arises here has to do with the notion that some of these folks who are appearing and are here today believe that the words and what that means with regard to open government mean that the governor and council meeting is a participatory undertaking. What the state indicates and what the state is arguing is, it is not. It is not. And it's interesting that even in the context of what's happened here today, in terms of trying to regulate and go forward, the court is trying to balance the notion of, we have open public courts, but we have to have order to proceed in order to be able to get business done and in order to have things happen. And so what I'm indicating to the court is, the government, through the governor and executive council and their agents, opened up the governor and council process because they knew there was an issue of some public concern, and they wanted to make sure that they got public input. So what would normally have occurred in terms of the governor and council meeting at the State House, in a room that might accommodate 25 people, was opened up initially at an auditorium at St. A's and then shut down. And then fairly shortly thereafter, this is the 13th of October, so 15 or 16 days later, because the business has to get done, it is announced and it is put on the grounds of the police management training, which has a large open auditorium that you could see, but it also has the ability, in terms of control that location and having the state police present and being able to be in a setting where they can sort of control, for security purposes, what's going on. As opposed to if you're at New Hampshire College or at, I should say, at St. A's, they've got their own security, whatever, and things can get ballsed up. So we have to have a meeting. The public has a right under our statute to access, and they've got a right to know. What they don't have is a right to participate. That's not in our state constitution.
You work for us.
They have a right of access to governmental proceedings, and records shall not be unreasonably restricted. So if there's written material, like an agenda is being put on there, or contracts are being considered, they should have the right to be able to go in and ask for a copy of that, to be able to see what it is. What they are not afforded to be able to do, and I think, quite if the matter goes to trial, you will have a witness who will come forward and say about the way that these proceedings are handled and have been handled historically. It's not a call and response. It's not, it's not something where, hey, Mr. Jones sitting over there in the corner, you have something to say. It's the governor and council going back and forth. It may be some discussion between council members and say, or you should have acted the Health and Human Services Director or someone else about aspects of a contract that's being considered because they're there in an official capacity and are there to answer questions, but it is not a setting for the public to participate or to voice their opinion. There are ample opportunities in many different forms, especially considering today's social media, for people to have an opinion, to express their opinion. There are locations, certainly in part of our state house, people are there regularly, holding up placards, walking around, distributing information about what they think about particular issues of the day, and they have every right, sort of our speaker's corner. And that's a First Amendment issue, and I don't have, and the state does not have an issue with people being able to do those sorts of things. The problem is that when they want to foist into a situation like a governor and council meeting, this is an opportunity for us to demonstrate and to disrupt. That's not okay from the state's perspective. That's not okay. And so the question becomes, with respect to all of these folks, because you can see from watching just even that little clip of video, that there are a lot of people who were like-minded with respect to the issues that were present, and were standing up, and they're holding up signs, and they're doing all sorts of things. Is there some sort of arbitrary enforcement? Like, why aren't the people who are doing some of these other things being arrested? And I think that the issue really becomes one of, essentially, there's some level of one of degree, where the state and the state police are looking at the situation and saying, if someone's there with a sign and they're trying to protest, and it's a silent protest, we're not going to intervene, even though that's conduct, certainly. It's not conduct that is fundamentally designed to interfere with the progress of the meeting and the business of the state in that context. But what I think you will see, and it's why we want the court to have, and I know it's a long video, Judge, and I will agree with Attorney Gans that there's a whole bunch of, in terms of the agenda at the front end, that deals with things that are not of particular interest to the folks that are here. And so a lot of that just sort of goes as routine business. Are we all in agreement? You have a home, and they go along. It's when they start to get into, later in the meeting, certain aspects of the issues that they're concerned about, that they decide it's time that they want to participate. And it's the state's position, given the truncated matter from what happened at St. A's, and given what happened 2 weeks earlier at the Health and Human Services building, that this can't happen. We're going to have business run. We have to approve contracts. The state's going to lose money for certain things that it's trying to do because we're not finishing meetings. And, I don't want to speak to officially all the, matters with regard to the September 8th Health and Human Services, because if that's a meeting where there's a public can participate, it may be a little different, but I'm telling you, at least there was interference with respect to that, and that meeting was not allowed to basically be completed. So I think what the state is arguing.
Interference by who?
The state has the opportunity in a situation here, and this gets to the issue of time, place, and manner, to basically be able to say, this is not the speaker's forum. This is not other places where certain speech may occur. This is a governor and council meeting. This is how this proceeds. You're let in because we have a constitution that acknowledges the right of the public to be able to follow what government is doing. But you're not here to participate. So, in this case, the reason we're asking the court to look at it is, I think what you will see is, very early on, the governor comes in, and as they're starting the meeting at a little after 10 in the morning, he makes an announcement. Having people are here, I don't want to say what he says, we're gonna try and proceed, we're glad that people are here, we're glad that people are here to watch what's going on, but we can't allow for disruptions, we can't have this matter be disrupted. Then over the course of the next, several minutes, most of the time, things are okay. There are a couple of times where things get a little bit, a little louder, a little bit more disruptive. There are a couple of times where I think the governor speaks and announces, look, we're happy that you're here, we want you to participate, but we don't, we don't
We want you to
disturb the
participate.
meeting, we don't want you to disrupt.